All right, my cell phone says 1 o'clock, so call us to order here. Looks like we have a quorum.
Yes, sir, we do.
Yes, very good. We want a brief description of the appeal?
Yes, sir. Application for appeal filed by Breeze Hill, Inc. with the Goochland County Board of Zoning Appeals. The applicant is appealing the May 1st, 2019 and May 13th, 2019 letters of the zoning administrator, contending that Breeze Hill has a vested development plan that permits completion of the Breeze Hill subdivision without meeting revised access requirements of a subsequent subdivision ordinance amendment concerning the number and type of accesses required. The applicant is also appealing a revised determination made June 18th, 2019, modifying the prior zoning administrator's letters and affecting Breeze Hill, Inc.'s vested rights pertaining to further development of the Breeze Hill subdivision. The subject property is identified as assessor's parcel number 43-1-0-50-0 and consists of 263.69 acres in the election District 3. The subject property is zoned RP Rural Preservation. The 2035 comprehensive plan shows this area as appropriate for rural enhancement.
Thank you. We're going to have open remarks from both sides first, and we'll probably listen to those, and then we will likely discuss the idea of jurisdiction on some of the issues that are being raised. But I think we'll start with the open remarks as brief as I guess we can keep them. So the appellant goes first.
Thank you very much. Mr. Chairman, one quick question before I launch in. Am I going to come back and address the substance of the appeal separate from jurisdiction, or should I just address it all now?
I would say, well, what I was going to have you do probably your original opening remarks, and then after that, address the jurisdiction.
Yes, I think the opening remarks give us an overall picture of the case, and then he's going to ask for each of you to address jurisdiction after each of you have done your opening remarks.
Very well. Thank you very much.
Sure
The
thing.
substance is later.
And at this point, do I think I need to swear you in as far as testimony?
Yes.
Is that correct? Okay. Not yet?
Witnesses, not the attorney.
Okay, my bad.
Fair enough.
We're ready.
Well, first of all, by way of introduction, my name is John Walk. I'm with Hurstel Fleischer downtown. I represent the landowner here, Breeze Hill, Inc. We have Mr. Thompson over next to the wall there, his wife Louise Thompson, and we also have the project engineer, Mr. Stig Owens, here today. So that's pretty much our side of the equation. In terms of what brings us here today, the history of the project has been summarized in your papers, but I'd like to hit a couple of high points about that. The project was zoned back in 2007. And significantly, under our proffers, we only have one use. Unlike the zoning ordinance generally that might entail various permitted uses, we only have one use, and that is residential subdivision development. We were permitted a specific density of 121 lots, and the development has a proffered conceptual plan, and among the proffers is that generally speaking, our project will build out as shown on this concept plan. Significantly, since we're talking about access here, the concept plan depicts 3 accesses to Breeze Hill. There are 2 accesses on Fairground Road, and then there is a 3rd access point out the back of the project connecting to an adjacent subdivision called Longwood. There is reserved right-of-way back there 50 feet wide that ultimately would connect up Breeze Hill out to Shepherdtown Road. However, by proffer, that rear entrance was specified to be for emergency use only. Now, in September of 2018, the Board of Supervisors substantially revised the access requirements, and it did so in 2 important respects. First of all, rather than just saying 2 outlets, they also have a requirement of drilling down into the internal configuration of the roads within the subdivision. And specifically, there is this notion of a choke point that at no point internal to the subdivision can you have a situation where lots are served by only one access. That was not required previously. The pre-existing ordinance just simply said have 2 outlets, which we obviously have based upon the existing outlets on Fairground Road. Equally important, and the county's papers largely fail to acknowledge this, is that by proffer, we agreed to that emergency-only restriction on the rear access because there was concern about cut-through traffic. And we agreed to that based upon the ordinance that was in effect at the time, which contained no restriction related to emergency only or otherwise. The new ordinance introduced this requirement and specifically disqualifies one of our existing entrances from consideration because the new ordinance specifically says any entrance that has an emergency only restriction on it does not count. So in those 2 important respects, the new ordinance absolutely conflicts with the terms of our proffered rezoning approval back in 2007. Now, sections 1, 2, and 3 have already been platted. They've already been developed. Those lots have been sold. People are living in houses in sections 1, 2, and 3. So they're largely not at issue here. However, we're ready to proceed with section 4, and now all of a sudden compliance with this new ordinance, section 9.13, became a point of controversy. Now, I'm sure you're sitting there wondering, when is this guy going to get to talking about jurisdiction? Well, right now is when that is. Our response was to assert that we had vested rights. And I'm sure you have read in the papers about Virginia Code section 15.2-2307. I'm going to try to keep the citations to statutes at a minimum. But what it does, this statute, it codifies a pre-existing doctrine in the law that said once you have gotten to a certain point in the development process, the locality can't change the rules on you. And you acquire what are known as vested rights, which mean the regulations applicable to you are locked in and can't change. And you get to complete your development in accordance with the rules that were in place when you began. That's pretty much what the doctrine of vested rights says. And so our reaction to this notion of section 9.13 applying to us was to assert that we had vested rights and that ordinance could not apply, and that we were subject to the pre-existing ordinance requirements, which were set forth in section 9.7. And as I summarized a moment ago, it's very simple. All it says is have 2 outlets. So we requested and obtained official zoning administrator interpretations that we had vested rights, that we met the requirements of the statute to acquire vested rights, and equally importantly, because we have those vested rights and because the terms of our zoning approval cannot be reconciled with this new ordinance, therefore it cannot apply to us, because to apply it to us would violate our vested rights. And that was the May 1 and May 13 determination letters that we received. So you might be wondering, well, if you got what you were looking for, why did you note this appeal? Well, the answer to that is also very simple. We like about 99% of those May 1 and May 13 letters because they clearly opine that we have vested rights and clearly opine that section 9.13 cannot apply to us because to do so would conflict with the terms of our 2007 approval. However, slipped into the letter was literally one sentence. That's all we're talking about in terms of our initial appeal, was one sentence in those original determination letters, which frankly was a gratuitous comment, because all the letter simply needed to say was you have vested rights, section 9.13 doesn't apply. And it says that. However, it went on to say that, however, under the pre-existing ordinance, your 2 outlets have to connect up with each other, so that every lot within the subdivision has 2 ways out. And that we disagree with, and that one sentence is why we noted our appeal. Now, In relation to the jurisdictional question, the answer from our standpoint is super simple. And that is, the zoning administrator has expressed statutory power to opine on matters involving vested rights. That's 15.2-2286. That's the code section cited in the determination letter. And it is the correct citation because it's expressed statutory power to opine on matters involving vested rights. Decisions of the zoning administrator are appealable to this board under 15.2-2311. So the statutory path for a vested rights issue to be presented to the zoning administrator as an initial matter and then ultimately to come to this board is crystal clear. And the confusion is because in our original appeal letter, we went on to say that the zoning administrator has misstated the requirements of the pre-existing section 9.17, and that as correctly stated, it should provide that we have two entrances, we comply. I went on to further provide an alternative rationale under which we complied with the pre-existing requirement, section 9.7, and so suddenly our appeal has been recast as interpreting the subdivision ordinance. But I want to be 100% clear on this. If I don't leave you with anything else, I hope to leave you with this, and that is that we're here to talk about vested rights. We're not here to talk about interpreting the subdivision ordinance because, frankly, there's nothing to say about that. The requirements of section 9.13 are crystal clear. There is no interpreting involved there. It clearly specifies you cannot have your roads funneling down to a single access internal to the subdivision. We have that. It also says you can't have an emergency-only access. We have that. So there is nothing to interpret about section 9.13. The issue that requires determination is, does that even apply to us on account of our vested rights? And we maintain that we have vested rights, thus 9.13 cannot apply. Now, Mr. Chair, that's pretty much what I've got to say on the jurisdictional question. Should I go forward and address some of my other points or sit down at this point?
How about sit down at this point? And
Got
we'll
it.
keep rolling. You'll be back here, I'm sure.
Thank you.
All right, thank you.
Good afternoon, ladies and gentlemen. Ms. Parker, if you would pull up my PowerPoint. I'm Tara McGee. I'm the Goochland County Attorney. And with me here for this afternoon's hearing is our zoning administrator, Anita Barnes. Also, the Director of Community Development, Joanne Hunter, is here. I'm going to limit my opening remarks to the jurisdiction issue, but I do have that in the PowerPoint. So you've got the slides before you and so forth. We're here on the appeal of a zoning determination, and you have the jurisdiction to hear the appeal of a zoning determination. But it has to be properly within the statutes. Let me advance. This is an area map which shows where Breeze Hill is located in Goochland County. And this is the concept plan of Breeze Hill subdivision, just to orient you. The Board of Zoning Appeals, as was stated in my memorandum, is created when a locality adopts a zoning ordinance, because it is the county's position that you do not have the jurisdiction to hear the appeal as it has been put before you today, because it's dealing with the subdivision ordinance and not the zoning ordinance. And that is what you have the jurisdiction over. As I went through, your ability to hear those appeals are for an enforcement of this article, which is Article 7 in the Virginia Code under Chapter 22, of any ordinance adopted, and that is a zoning ordinance. So that's what you have the right to hear an appeal from, an order, requirement, decision, or enforcement related to the zoning ordinance. The Goochland County Ordinance similarly says that your appeals come right from the administration enforcement of the county's zoning ordinance. And finally, there's like a lag here between this button and that. Finally, your bylaws, as you say, follow that language and say that you've got to be associated only with the zoning ordinance. While he didn't name it by name, when Mr. Walk said the ordinance changed, the ordinance changed, the ordinance changed, that was all the subdivision ordinance. and that is the principal reason why you do not have jurisdiction to hear this appeal. Subdivision and zoning are both areas of land use, but they are separate. So in left, I have listed in the red all the sections of the Virginia Code that deal with subdivision. And you have the adoption of an ordinance, administration of the ordinance, how you approve subdivision things, appealing a denial of them, and a separate ordinance under which you obtain vested rights in a subdivision plat. And on the right-hand side are those similar things addressed in the Virginia Code for zoning. So they all handle those same issues, very separate laws, separate authorities, and vested rights in and of itself has a separate action under subdivision. And then at the top, I've also written, the county has two different ordinances. They have the zoning ordinance, which is Appendix A, and the subdivision ordinance, which is Appendix B, which is all that I've stated here that matches up. Let me give you an example. Kinloch subdivision, the county's to date largest subdivision. It was approved back in 1997 by zoning, the action of the Board of Supervisors. That was what, 30 years ago now? It's being developed in sections, and each section of Kinloch that comes forward files a subdivision plat. And that's when that subdivision and section is then built and approved. The last Kinloch subdivision section happened in 2018. So the subdivision process comes along behind zoning, has the specifics of each zoning lot shown on a plat, and is when construction happens. But those are the difference between zoning happens once and exists for many years, but then subdivision sections come in and get platted and go forward. So that's just to give you that concept. So, based on what I've shown you in your authorities, you have authority for decisions relating to the zoning ordinance, but not something with respect to the subdivision ordinance. This is the zoning administrator's determination that is before you on appeal. It says that development in Breeze Hill can occur consistent with the approved resolution. We showed you that as Exhibit 1, and you did have before you a notebook of our exhibits. Those are to have an organized place for our exhibits. They're not new from what was submitted to you. They're just tabbed and put before you. And in substantial conformity with their approved schematic plan, which was Exhibit 2. In Exhibit 1, the resolution, several of the proffers that have been brought before you, it is absolutely true that there is a zoning vested right into 120 lots, 121 lots under zoning, because that is use and density is able to be a vested right. The other things also go to some of their zoning proffers, and when a proffer is accepted, it actually becomes a part of the zoning ordinance. So they have to build in compliance generally with their schematic plan. There's conversation about the outlets that were to be conducted, the turn lanes that were to be constructed. Also, there's a proffer D that says all lots shall access Fairground Road as generally shown on the schematic plan. That was a proffer when the case was originally zoned back in 2007. The issue that ends up bringing this dispute today is that there is a connecting road there between Section 1 and what becomes Section 4, and Section 3 and 4, and then 5. And that road, while platted on the Section 1 and Section 3 plats that have already been approved, that road of way has been dedicated and is shown, has not ever been built. And so that's where the dispute ends up coming up. Let me just be very specific about what appeal grounds are before you. This is what was in the June 21st letter to you about the appeal. This is what grounds the appellant has asked you to take, or what actions. First, it says, I'd like to continue on the grounds I put in my May 30th appeal. Second, it says, we think you should completely reject the June 18th letter that changed the earlier letters. And finally, a ruling that Breeze Hill may complete its development based on the 2 existing outlets and the 3rd emergency outlet. And I'm just going to go through these one at a time briefly. Because the appellant's grounds don't actually challenge or contest this determination. And that's what it has to do to be before you. There is not a single ground that says, no, we don't want to develop inconsistent with our resolution, or we disagree that we can develop inconsistent with our resolution. This is what they have before them. Their grounds do not relate to this. So with respect to the May 30th appeal, that's where the appellant specifically said, please say I'm protected from the change in the subdivision ordinance. And That's not be before you. The vested right in a subdivision ordinance comes when you get a plat approved, not from a letter. Or it says, please let me allow to develop with the rear access point. Frankly, that's also part of this change in the subdivision ordinance. The second ground is a request to throw out our June 18th letter. The modification of that letter is not only authorized under the state law that says a zoning administrator can change a determination within 60 days, and this was within the 60 days, it's also actually required to be changed because those initial letters were outside of the zoning administrator's authority. And from the case I've cited to you that's in the Zoning Administrator Exhibit 11, there's a case that tells you that it's a nullity, that a letter outside of her authority is of no legal significance. And so we had to change it. Finally, the third appeal ground was simply that allowing you to, getting your permission to continue their development this way. That is not the subject of the zoning administrator's determination, and this is just a restated request to rule about the subdivision ordinance amendment without naming it by name. So it is the zoning administrator's position that the BZA, while you're a body that has things to do, this is not within your jurisdiction. It seeks a determination regarding the application of our county subdivision ordinance, and the appeal grounds do not actually challenge or contest the language of the zoning administrator's determination that's before you. So we would simply request that you rule at this time that you don't have jurisdiction on the grounds of this appeal. Thank you.
Thank you. Would y'all like to go discuss this with our attorney, see for some clarity?
Yes.
Okay. Okay. I move that our board, the zoning appeals, will go into a closed meeting for consultation with our legal counsel regarding everything we just heard. And we'll try to be as brief as possible. All in favor? So moved.
You need to do it now. Yeah. Go into the closed session. Any one of you can make that.
Okay. Read this, okay. I hereby move for certification pursuant to section 2.23712D of the Code of Virginia that Goochland County Board of Zoning Appeals, to the best of each member's knowledge, heard, discussed, or considered only public business matters lawfully exempted from open meeting requirements by the Freedom of Information Act in the closed meeting of this date. And only such public business matters as were identified in the motion convening the closed meeting were heard, discussed, or considered by the Goochland County Board of Zoning Appeals. We good?
Okay.
First,
So you
second,
just
all in
want,
favor?
you want to speak to the consensus, or do you want to?
I will now. Yeah, our discussions, what we decided as a group and all agreed, that we are, one thing we cannot do is just grant permission for the subdivision to just move forward. That's not really for us, and that we won't really rule, in specific on the subdivision ordinance itself. We will listen and decide on the three letters that were sent out by the zoning administrator and the language that was used there. Any discussion that county or appellant would like to have regarding that, and some of the different language in the letters to make to better understand that is something we will gladly hear on.
So recapping,
Please.
you're going to ask everyone the two attorneys to speak to and be focused on the issue
The
of you can speak to all three letters and the actual language, exact language used in those by the zoning administrator in their determination.
Correct.
Well, the first one wasn't
Thank
the zoning administrator,
Right.
but we want to focus on the language of the determination.
And staying
And then
away
we'll
from
proceed with the
zoning ordinance.
hearing.
Yes. Yes. So we can begin, I believe, with
I'm
testimony.
going to ask if both
Yes.
sides are comfortable with that, or do they feel
Yeah.
they have to have any motion on jurisdiction at this time? Because we could take that later. I mean, are you comfortable with the consensus?
Board's pleasure, I'm ready to move forward.
As long as the board's jurisdiction is addressed at some point in a motion, I'm happy to go forward with what we have now.
Okay. It just seemed easier.
Testimony from the appellant, I believe, is next.
Right.
Yep.
Thank you so much. Let me pick up where I left off earlier. Again, I mentioned this somewhat briefly in my original comments as to, why it is we're here. If we're,
Clarify, excuse me, is it additional opening or
Yeah.
testimony?
You want to pick up at the argument, don't you? It's up to you as the chairman, but.
I was going to pick up at testimony. Or do I have the wrong order here? We kind of did opening
Yes.
remarks, or should we repeat that?
Substantive testimony addressing the substantive issue. So your opening remarks you've already given. You gave remarks on jurisdiction. Now we're looking for the body of your argument on the
and
substance.
that's where I was going, was
Okay.
to be directly responsive to the question about what is it about the letters that we don't like? And what is it we are suggesting that the board do about it? Which,
Very good.
as I understand, is exactly the mission that
Yes,
we've been
sir.
given. I'm going to try and stick to the mission.
Thank you.
The letter that I'm referring to here is the May 13 letter. The language of the May 1st letter is identical. The two letters are the same, just one was signed by a zoning official other than the zoning administrator, and I asked to get the letter reissued under the signature of the zoning administrator. So frankly, it doesn't much matter which of those two letters you refer to, but I happen to have the May 13 letter in front of me. And specifically, if you go to the second page of the letter, as I said, we are okay with everything in this letter except for one sentence. And that one sentence is the first sentence of the first full paragraph on page 2 of the letter. The rest of the letter is a pretty clean decision that we have vested rights. That much is not an issue. But more importantly, simply saying we have vested rights doesn't mean a whole lot unless you say what that means. And the letter goes on to say, and what that means in this case is that this new section 9.13 cannot apply to you because it conflicts with the terms of your approved rezoning. So all of that part of the letter is fine. The one sentence that caused this appeal is the one that reads, "The road network depicted in the schematic plan provides every lot, that's the key, in Breeze Hill with access to 2 outlets through the 2 Fairground Road entrances, thereby comporting with the access requirement language of the original 9.7 and the language in 9.13. That sentence is what we are seeking to have stricken from the letters. In all other respects, we would ask that the board affirm the May 1 and May 13 determinations minus that sentence. Now, when we noted the appeal, we went on to explain what it was we didn't like about that sentence and why we thought it was inaccurate, and I want to expand upon that now. First, as has been alluded to previously, the point in controversy largely relates to this earthen dam that creates the pond or lake in the center of the development. There is an old farm road that goes over that dam, and the original concept plan that accompanied the 2007 rezoning envisioned incorporating that road into the subdivision layout. Now, importantly, I got to go back to what the proffers actually say, because that conceptual plan is only part of the proffers. But what the proffers say, specifically proffer A, it doesn't say that we have to build exactly what's shown. It says what we're going to build is what's generally shown on that plan. And even more to the point, it goes on to specify towards the end of proffer A that specifically the roads can change at the time of design as needed, and that the point where the roads will be really finalized will be at the point of subdivision plat approval. And in this case, very importantly, the either end of that earthen dam joins up with Section 1 and Section 3 of Breeze Hill, both of which have already been approved. And in both cases, the subdivisions were approved without that connection being required. And let me explain a little further about why it is we are concerned about that dam. First and foremost,
Mr. Chairman, I'm just going to ask, is this a summary of testimony you're going to be providing, or is the attorney testifying? That's not what's clear to me.
I'm speaking on behalf
I
of the
believe this is his
applicant.
testimony.
Yes.
He's making his argument. If he wishes to call a witness to substantiate his argument,
Right,
that's
'cause
up to him.
Right, because we're not taking testimony from him.
Well, technically,
I-
you begin with argument, and if he wishes to have a witness testify, he can do that. So you can continue your argument.
And I am speaking on behalf of the applicant here. If you want me to swear to this, I will. I do have a couple of witnesses that I want to call to supplement my comments, but I'm speaking on behalf of the applicant. I'm not planning on calling Mr. Thompson to then go through and repeat everything I just said.
Right, again, I'm happy to have him describe to you the testimony he intends to call, but it's not appropriate for him to summarize the testimony or to testify instead of the applicant. Our opening statements are to tell you what evidence we intend to provide, but then you need to have that evidence brought through testimony or documents. And I just want to clarify that Mr. Wall keeps saying I'm speaking for the applicant. He can make a statement on behalf of the applicant's attorney. He can't testify for him.
Yes, I think the one point I will say is the proceedings here are similar to court, but less formal.
Of course.
And he's giving argument. He probably should, you will have a closing remarks on the agenda
Yes, we
for
do.
summarizing what's been presented.
And rebuttal.
And so if you are making statements of fact that you wish to have substantiated, you would be within your rights to call a witness, and you may want to do that. We do want to try to move this along in a reasonable time, but, you know, the chairman will manage the time.
Very good.
Does that satisfy you? Okay, so if there are technical issues you're speaking to, you may wish to have your engineer address them.
And
Or just to affirm what, you know, you can keep that
I'm
short.
planning on doing that.
Okay, you can keep it short, but.
Terrific. Again, significantly, the proffer says that road plans can change at the time of plat approval. And in this case, when Section 1 and Section 3 were platted, those road plans were approved without this requirement, without the requirement of this connection being made. Now, what is it that we object to about making this connection? I'm sure there will be the suggestion that we're just trying to save a few dollars. That's actually not the case. Importantly, and we have Mr. Mark Kilgore here from the State Department of Conservation and Recreation Dam Safety Program, who can speak more directly to this than I can. But what would be required? First of all, state doesn't want the road, period, because they don't regard it as safe. But more importantly than that, in order for us to even wedge this road through a crack in the regulations that might theoretically permit us to build it, we would have to do things like lower the height of the pond and construct significant and very unsightly downstream drainage improvements, which, aside from cost to Mr. Thompson, it would substantially detract from the natural setting of the community, which, as you can see from the proffered concept plan, this whole subdivision was envisioned with 50% of its area reserved as natural area. And the residents very much prize the natural setting that is offered by Breeze Hill. And so even for us to theoretically do this would entail largely wrecking the very thing that they purchased lots in the community to find. So the residents don't want it. I don't think you'll hear the fire marshal say that he wants fire trucks driving over a dam either.
Objection. Two things. One is, I need to know when I call the fire marshal, that would be appropriate to mark it up. But again, I think we're well beyond what Mr. Parker told us.
Yeah, I will say, I don't see any mention of the road in the letters. I don't feel like, somebody may have told you couldn't build the road, but I don't,
If
I
you,
didn't really know the road was a specific topic for us as far as the language of these letters.
so
I don't
this,
know if that's off
I
base
believe
or
you,
not.
I believe you have addressed the road to some extent in terms of the basic or impetus behind this. And if the board members have further questions about that, I think they can ask at the end of your presentation.
I realize that does seem to be at the crux of the matter, but I don't feel like we're being asked whether the road should be built or not.
I
Like, that's not in our
understand,
letters.
I
Okay.
understand completely.
Okay, so I didn't want to go off too far deep down the road
I understand
and then
completely.
near into that, because that's
I
not on our table, I thought.
I
Okay.
understand where you're going, Mr. Chairman, and what I'm trying to do is explain that this statement, you may feel like we are nitpicking to extract one sentence out of a letter and say, that's what this appeal is about. But in our mind, when we saw that sentence, that was code. That was a veiled way of saying to us, you may have vested rights, but we're going to hold you to build this road over the dam in order to realize on your vested rights. And that is what we disagree with. We're perfectly prepared to fight another day in another
Right.
forum before another body about our subdivision approval. What we are seeking from you is a simple statement that we have vested rights, and because of our vested rights, Section 9.13 has no application to this project. And then we'll take it from there in another forum on another day. But I did want to be very clear about what it is about that sentence that we disagree with, because we very much interpreted that as being about the dam. And the reason why we disagreed with it is because if, as we contend, we are subject to Section 9.7, the pre-existing ordinance, then all it said is have two outlets, and we have two outlets. And there is nothing in the ordinance that entails anybody getting into the internal road configuration of the subdivision. And that's why, frankly, Sections 1 and 3 were approved without requiring that connection to be made. Let me move on to another point. And again, well, before I do so, let me just cap off that part of my presentation by saying, just to be 100% clear on what it is we're asking this board to do, it would be to reaffirm the May 1 and May 13 letters minus that sentence that I identified at the top of page 2. We also went on in our appeal letter to say that since the zoning administrator went on to launch into what would have been required under Section 9.7, then at least it should do so correctly. And a correct statement of what 9.7 required is simply that we have two outlets. And we would ask that you consider incorporating that into your ruling as well. But again, we are not asking you to delve into the specifics of the subdivision plat approval process. That is another fight for another day. Now, let me move on to talking about the June 18 letter. We noted this appeal and did so within 30 days of the May 1 letter. I think it was May 30 that we noted our appeal. Significantly, the statute and this board's rules provide that any party that has a problem with a zoning determination letter can appeal it to this board within 30 days. And that's not just private parties. The statute talks about there may be a situation where the zoning administrator renders a determination that the locality itself decides it doesn't like. Well, the locality has the ability to appeal the letter to this board within 30 days. And the statute goes on to say that if you fail to do that, then the determination is, quote, final and unappealable. And significantly in this case, the county noted no appeal of the May 1 or May 13 letters. And so in our view, they are final and unappealable. And we would ask this board to make that ruling as well. Now, the county's take on this is there is another provision, it's actually in the same statute, but another subsection of the same statute, that announces a broader rule that is applicable to generic determinations by planning officials. In other words, not official zoning determination letters, which is what we have, but more generically, any decision or determination by any local official dealing with planning or zoning. And it says it's subject to being changed within 60 days, or rather it cannot be changed after 60 days if the landowner has relied upon it. And that is the basis upon which the county has purported to retract the May 1 and 13 letters and to substitute this June 18 letter. So let me address why it is we feel that the June 18 letter was of no force or effect when it was issued and should be overturned by this board. First of all, as I previously mentioned, the earlier determinations were not appealed within the 30 days. So that provides a very simple basis upon which to disregard this later letter. But then secondly, under this 60-day rule, remembering that it's broader than dealing with official zoning administrator determination letters and deals with any opinion or determination by anybody involved in the planning or zoning process. This determination that Section 9.13 didn't apply to us dates back to February of this year. Under the code, the zoning administrator, in opining on vested rights issue, is supposed to do so in consultation with the county attorney. And in this case, we went to the county attorney first on the vested rights issue, and the determination was made back in February of this year that Section 9.13 didn't apply because we had vested rights. So we submit that the June 18 letter was not done in a timely fashion because more than 60 days had passed, and we had obviously relied upon that initial determination by doing a ton of planning in terms of platting out Section 4, doing engineering for our roads in Section 5. All of those things were submitted to the county, and all were done in reliance upon the initial February determination of our vested rights. But more important than either of those two things, the original determination was the right determination. So I don't want to just stand here and try to convince you that somebody tripped up and missed a deadline. I want to convince you that the original determinations were correct. And on that basis, I would point to the reasoning in these original determination letters as to why it was Section 9.13 could not apply to Breeze Hill. And the reason is this, that if you look at our proffered concept plan, it shows a single spine road. There are the two entrances on Fairground Road, but they come together. And then there is a single spine road that leads down and serves sections 4 and 5, terminating in that rear access point out to Blackwood Drive that has the restriction on the gated entrance and emergency access. Section 9.13 conflicts with the terms of our zoning approval in that it, number one, expressly prohibits that kind of single spine road configuration and requires that we not have any choke point, which obviously there is. And stated right in the letter is the fact that we cannot possibly comply with Section 9.13. There is literally no change that we could go and do now because Sections 1, 2, and 3 are already there. We can't go back and reconstruct them. And so with the choke point in place, we cannot possibly meet Section 9.13. And on that basis, the ordinance cannot possibly apply to us because it would conflict with the terms of our 2007 zoning approval, which are the basis of our vested rights. But that much is stated in the letter. There is a second basis, though, however, that is equally important, and that is that we agreed to that proffer related to gating the rear Blackwoods Drive entrance. There's no compulsion for us to have agreed to that. There's 50 feet of right-of-way reserved right out to Blackwood Drive and out to Shepherdtown Road. It was certainly envisioned that we would have a through access there, but the neighbors, and at this point, frankly, the residents don't want the cut-through traffic, and so we agreed to gate that entrance. Why? Because there wasn't any reason not to under the ordinance at the time. Now suddenly the ordinance has changed to say you can't have that. But we already have that, and we can't go back and unproffer that proffer at this point. We are stuck with it, absent, of course, going back and just rezoning the property. And so on both of those reasons, the stated one in the letter and the second one that I have offered, because Section 9.13 irreconcilably conflicts with our vested rights, it cannot possibly apply. Now, when you go to the June 18 letter, in terms of what's stated here, you may say, well, Walk, what's your problem with that? Well, the answer is what's missing. Because if you go and you compare this letter to the earlier letters, what is missing is all the stuff about Section 9.13 not applying to us. That has been carefully excised out of the first paragraph on page 1. There is the entire section regarding the choke point analysis has been deleted out of the letter. And then towards the end, in the conclusion, the earlier letters opined that we had vested rights such that Section 9.13 could not apply to us. That has been deleted in favor of just simply saying development can occur consistent with the approved resolution and in substantial conformity with the approved schematic plan. Well, you might say, well, that sounds pretty good. What are you complaining about that? The answer is that literally on the same day this letter was issued, we received a second letter, which is in the papers that we have filed, rejecting our Section 4 subdivision plat. And the stated basis for rejecting our Section 4 subdivision plat was the fact that we did not comply with Section 9.13. And so the county has gone from sending us the 2 determination letters back in May that says Section 9.13 does not apply to us, and has now done a 180 and is now saying 9.13 does apply to us, and they have rejected our Section 4 subdivision plat on the basis of that. And so on all of those grounds, I would ask this board to disregard and overturn in full the June 18 letter as being A, untimely, and B, incorrect in its conclusions, that the original letters were the correct conclusion to be drawn. Reaffirm those original letters in their entirety, including the analysis and the finding that Section 9.13 irreconcilably conflicts with the terms of our zoning approval. Reaffirm those letters minus the one sentence that I have identified. And with that, we will call it a day before this board and take up any remaining issues with another body. Now, I do have some additional testimony that I would like to call in support of our comments, but that will conclude my presentation.
Okay, do you have witnesses you want to call right now?
I would like to, yes? Yes?
Yes,
Yeah.
this is the case in chief portion, so feel free.
Perfect. Well, let's hear from Mr. Mark
On this,
Kilgore,
let me
please.
read, yeah.
Right. Question?
Mr. Chairman, I think it would be appropriate to ask for a summary of what Mr. Kilgore will testify about, since in his opening remarks, what Mr. Walk said is that he would testify about the road against the over the dam, and as the chairman has stated, the BZA has decided the road against the dam is not before them. So with that being said, I would object to the testimony of Mr. Kilgore, it's not relevant or pertinent to the issue before the BZA.
Any comments?
Well, first of all, you can consider a proffer if you like. I would like to present it for purposes of the record. If you choose not to consider it, that will be your choice. I do think it is appropriate because, again, the specific sentence that I identified that I'm requesting the board to strike out of the original determinations is essentially about the dam. And I would like to have before the board that this is not just a matter of us saving a few dollars on building a road, that the road over the dam actually is not safe. And I believe that would be appropriate for the board to consider.
Well, Mr. Chairman, I believe it would be up for you as a body to decide the relevance of the matter.
Okay.
But I think that you can do that in your deliberations. That you could decide whether you want to give weight or credit to the testimony,
So you're saying we can hear it and decide later?
basically.
Any
And
thoughts
so the
now
point's
whether-
been raised, the point has been raised that you should do that.
Okay. Should do what? Hear it? You
The
like to hear
county's
it?
raised the point that,
I think it's good to get on the record.
I mean, it just, in fairness, it will give you the larger record, and then you can decide if that's even relevant to your deliberations.
All right, we will hear it and decide later whether to include it in our evaluation.
Very good.
And I have an oath for you, kind sir, all right?
Yes, sir.
I swear that the testimony I'm about to give is the truth to the best of my knowledge.
I so swear.
Thank you. State your name,
Yep.
please, and all that.
So, good afternoon. Pleased to be here with the commission. My name is Mark Kilgore. I'm a professional engineer, licensed in Virginia, specializing in civil engineering. I'm also a certified water resource engineer, and my role is the dam safety engineer for Region 2 of Virginia, which encompasses Goochland County. So this is an area over which we have authority with respect to dams that meet our criteria. And this dam does meet our criteria according to state regulations. The points, and I've given both an electronic copy, I've brought written copies if either anybody wants to have a written copy.
Okay.
And so I'll give you a written copy.
Do you
But
have enough copies for the members as well?
I have if they're willing to share, so. I do need to keep
Is
it.
this going to be the subject of your testimony, Mr. Kilgore?
So yeah, this is what I'm basically here to discuss, the interest of the state of the Commonwealth of Virginia with respect to roads on dams. So we are in the middle of a rulemaking, and I start off my remarks by mentioning that roads over dams have to have a spillway design in the event that a flood occurs, such as those that occurred under Hurricane Camille and more recently under Michael and Florence. And there are specific technical criteria for coming up with these. I won't get down to the nitty-gritty, but basically, we know that Shepherdstown Road downstream of the dam carries more than 400 vehicles per day. We have numbers from the consultant that indicate it's about a 570 average vehicle count per day. And normally that would drive the dam to what we would call a significant hazard. So we have three criteria: low, significant, and high. And by definition, a significant hazard roadway is one that could cause property damage or could cause loss of life. A high hazard dam, on the other hand, is more severe. It likely would cause it. So, I wanted to give you like a demonstration, because you know that if you're driving over a dam and there's a spillway on the dam and your car lands on that spillway, either at the moment the dam breaks or that a flash flood sends a wave crashing over the dam, that car could potentially be in jeopardy. So that's the property side of it. And a fall off a dam in a car could also result in injury, even death to a person. So contrast that with a road downstream of the dam. Let's say it's a quarter mile downstream. The flood comes through, the water level rises, it starts going over the road. There's an expression, turn around, don't drown. Most reasonable people seeing that wave crashing over the downstream road would turn around. But if you're already on the dam, you don't have that option. So that's, I'm trying to give you the basis, the technical basis for why we don't really appreciate constructing new roads on dams. Now, we do have one situation when it's the only viable alternative. In other words, in a high mountain valley, the only egress is over the dam, and in which case it would have to have extensive design aspects to address the issue of the road on dam. That could include like a bridge over the spillway so that your car wouldn't be at risk, but the main dam could still pose a risk if it failed and create jeopardy. But I did want to state that this is currently at the state of policy under development, that we are undergoing a notice of intent of a regulatory action, and we're collecting public testimony on these issues surrounding roads and dams. So our regulations are not very explicit at this time, but it is a common sense interpretation of how our regulations are written in terms of this contrast that I've just shared with you. So we wouldn't look at incremental dam breaks. We wouldn't look at some other methods that are out there. We would just say, if the study that the consultants are undertaking to do a DBIZ study, a dam break inundation zone study, prove that it's a significant hazard dam, we would require the dam to be designed to pass this, what we call half probable maximum flood. It's about half the size of Camille. It's about 18 inches of rain in a 24-hour period. And it produces a lot of water, even from a catchment as small as the one at Breeze Hill. So that basically, along with our guidance document, which I'll also provide the court reporter, summarizes my remarks, unless there's further questions or clarifications from anyone.
Any here?
I do have a question.
Okay,
Sure.
go ahead.
So just so I understand, thank you for your testimony. So you're not saying, so how did you come to be involved with this project?
So we are the agency that issues a certificate to the dam owner by which they conduct these studies, like the DBIZ, the Dam Break Inundation Zone study I mentioned. We work with the dam owners to bring the dams up to code. We want the dam, when it's turned over at some future date, perhaps to a homeowners association, to be fully compliant with our regulations and under what we would call a regular certificate. That's the sort of our gold standard, that everything is up, running, and working as it should. The other option is if the dam is decommissioned in some way, either taken out altogether or is lowered below our regulatory threshold. That is to say, the crest level is reduced such that it no longer contains more than 50 acre-feet of water. Jurisdiction then reverts to the county and its authority at that point.
Thank you. So at this point, if the dam were to go, so are you saying that they would not be able to get a certificate based on what is known today?
No, they're in the process of conducting studies. What we would question would be our ability to allow an alteration permit proposing a road over the dam through the spillway that would potentially put somebody in jeopardy. In other words, we would go through a review process. We believe that other locations, if feasible, should be looked at for connective type traffic. And I'm not a traffic
Right.
engineer, I'm a water guy, but that, you know, that's where it's much more appropriate to look downstream or upstream or someplace else to meet the requirements of access, should that be found was it 913 or 713 was applicable to this development. But
So just for clarification, so what you're
Sure.
saying is, nobody's told them they can't do this right now. So nobody said this is not feasible. However, they haven't said it's okay
Right.
either.
they have not put before us an application for an alteration permit. So I have nothing in front of me right now, but what's been offered is the possibility exists
Sure.
that should we be compelled to construct this road, that we will have to file an alteration permit with you, and that alteration permit will have to address safety issues with regards to vehicle traffic over the dam.
Fair enough.
And we have significant concerns about vehicle traffic on dams.
Sure. Thank you very much.
Anyone else? Thank you, sir.
I'd like to call Louise Thompson, please.
Okay.
Thank you. I'm
Yes.
Louise Thompson. Oh, do I have to?
Yeah, I'm going to give you those, Ms. Thompson. I swear that the testimony that I'm about to give is the truth to the best of my knowledge.
I do.
Thank you.
I'm Louise Thompson. I have a couple of roles in this. My husband is the developer, so we're the developers of the neighborhood. But I'm also a real estate agent who handles the sales in Breeze Hill for all the neighborhood. And I am the temporary person for the homeowners association, as we have not turned the neighborhood over to the residents at this time. We wanted to get a little further ahead in the numbers of people, and we're working towards this fall, turning it over in 2020, in the spring of 2020 to the owners of Breeze Hill. The couple of things that I think are most important to the owners right now, and Mr. Walk touched on it, but I know this is not really your purview, is the...
If I may, I apologize to the extent Ms. Thompson is going to speak about how the neighborhood owners feel about this, that has no relevance to what's before the BZA or the appeal or action, so I would object to it as irrelevant, shouldn't be permitted.
Thoughts,
Okay,
counsel?
perhaps one of my comments might, because I handle the sales.
If you
and-
could reiterate what your position is with the
Okay.
HOA?
Okay. Sections 3, 4, and 5, and the question about the outlets, and if it should be developed as it is.
Wait, I just wanted to know what your title or position is with the homeowners association.
I'm the temporary president, if you will. I handle the homeowners association until it's turned over to the residents.
They have to be, until they're established, they're not established.
No, they're staffed by the developer often. Do you have a basis? If you wish to make a statement representing the owners, you should establish your basis for representing the owners, whether you had a meeting, discussions, or something of that nature. And again, the relevance of it would be something you all can decide whether you wish to consider that at all or give it credence. So if you want to make any statements about the homeowners, you should establish the basis on which you're representing them.
Okay.
That's a nutshell version you have, would be great.
In
Otherwise, restrict your remarks to your other roles.
Okay. With respect to the homeowners, we've had emails, telephone conversations, personal meetings with owners. And the owners feel that the way sections 3, 4, and 5 are being developed in the road configuration, the way it is satisfactory to them.
Are these all owners in the front sections then, that are saying that
Sections
that's
1 and
okay?
2, and Sections 3, the people that are under contract, I have to be very clear with them what the road layout is and where it stands. And we have owners under contract. Homes are, I would say, 75 to 80% complete. Just put new owners under contract, have just put new lots on hold to build and discuss building. And these people are all aware of the way it is, and it's fine with them. They're proceeding.
Can I ask a follow-up? You said that you have to let them know. What do you show them?
I give them a homeowners association package, the disclosure packet that's required.
I'm sorry, about the road configuration specifically. You said you show them the roads and they're fine with them. What are you showing them?
Showing them the schematics, the original schematics, showing them the recorded subdivisions plats, for example, sections 3, showing them the recorded plats.
Would you be showing them like the first approved ones?
Like what we're looking at over here?
I show them everything. I show them everything I've got. I show them section 1, section 2, section 3. I show them the schematics. I do tell them that until subdivision road plans are approved, that roads may change.
Okay.
I explain, for example, how we changed one road in Section 3, going out to Fairgrounds Road, how it changed from the conceptual plan, that the conceptual plan is a guide,
Sure.
but until it's approved.
Would it be fair to say then that you're showing them the road with the schematic with the road with the dam?
It's there,
Sure.
and they're aware of it. They know that it may or may not be built.
Okay.
They are specifically told that and discussed.
Sure. Thank you so much.
Thank you very much. so.
Thank
Yes,
you,
sir.
Testimony, thank you.
Okay, very good. We'll hear from the county now.
At this point, I don't intend to offer testimony, but to speak to the information before you and the exhibits that are before you. And if I could pull up my PowerPoint where I left it off. If you could go to slide 22. Actually, I suppose. I'm going to try and weave together both the things that I had prepared on my PowerPoint together with the information that I've heard from appellant and try and cover everything I need to. The first thing I should start with is what the BZA standard of review is. You all sit on an appeal of the zoning administrator's determination, and so by law, the determination of the zoning administrator is presumed by you to be correct. And the burden of proof to rebut that presumption of correctness is on the appellant, and it has to be met by a preponderance of the evidence. And that's just the state law authority about what we're doing here. I'm going to be brief because I've already heard this, but in fact, the appellant has not challenged the zoning determination, and it is helpful to have these two statements before you, because what the appellant said when he stood up, the first thing he said to you was that he was requesting that a specific sentence be struck. And I ask you, from the summary I've put here, as well as from the documents in the record before you, where is the request to strike that? It is not in those documents. And the appellant cannot stand in front of you and me today and suddenly have a new request on his appeal. The reason that appeals are in writing and by notice and the grounds are laid out are so that we all can prepare to what we have to deal with. These are the summaries of what he has asked for, and not one of them is to strike that sentence. Moreover, that sentence that he wants to strike, there's only one thing it deals with, and that is the application of the subdivision ordinance, section 913, which I spoke to you before about, is outside the authority of this board to discuss. It's outside the authority of the zoning administrator to even opine on. It was removed from the June 18 letter, as explained in a letter to Mr. Walk, because it was completely improper for her to remark on it at all. So that's why it was removed. Let me ask you next to look at the zoning administrator's exhibit number 12. The very last in the booklet that I provided you. Now, I only provided you 2 pages, okay? This is the 394-page Albemarle County Land Use Law Handbook, which I shockingly did not give you all. What I gave you is that cover sheet, and then the only page you need to know. And that's because what Mr. Walk and the appellant would like you to talk about is vested rights. But that one page that I have provided you talks about vested rights. And what you see is that it is true under 2307, as cited by Mr. Walk, you can get vested rights. A landowner is entitled to vested rights from changes in the zoning ordinance. There's no change to the zoning ordinance before you. Under the next section, again, there's a way to vest from changes in the zoning ordinance. Under the 3rd paragraph, there's a way to vest from changes in the zoning regulation changes. And then is the 4th paragraph that talks about the ability to vest in a subdivision plat or site plan. And that ability to vest comes with the approval of a subdivision plat or site plan. And so when you talk about vested rights, you can get vested rights in a subdivision plat once it's approved. That doesn't come from the zoning administrator. It does not come by virtue of a zoning determination. And the things that Mr. Walk originally asked for, what the appellant originally asked for, was a letter under 2307. And we did mistakenly provide a zoning determination when in retrospect, we shouldn't have. We should have said, I'm sorry, we're not allowed to talk about the subdivision ordinance. That's not how you vest in changes. That was absolutely our error. And we corrected it when we learned of it. We tried to give them a zoning determination at June 18 that then stuck to everything zoning, because that's the only thing the zoning administrator had authority for. So I think it's important that you understand when the appellant's talking about vested rights, there are these different subsections under the different zoning and subdivision, and it's not just vested rights generally. What we have before us today is not a request for a vested right against the zoning ordinance change. Again, I just wanted to put before you the summary of the jurisdiction. I will not spend any time on it. But then let me go back to what I did not talk about in jurisdiction, which is the zoning administrator's authority. Because like yours, it is limited to dealing with the zoning ordinance. And this is the state law summary that says that she can talk about administering and enforcing only the zoning ordinance. And that is all that she has the authority for. Similarly, I cited to you the cases that hold that. They're very short cases, thank goodness, because I went ahead and gave you the case authority. Here, the Reston case is Exhibit 11 in the zoning administrators. Very simply says that something outside her authority is void. We were obligated to withdraw the May 1st or May 13th letter because they were illegal. They meant nothing. We weren't intending to do that. We regret that we did it, but we tried to make up for it by giving the June letter. The subdivision ordinance issues that are raised do belong in circuit court. And let me start here. The Section 4 subdivision plat that was denied, that is in fact a part of your record. The appellant included that in the final submission of exhibits. I think it was attached to his 5th exhibit. Hang on, I have a summary here to try and help me wade through this. And because what we discovered, as I showed you about the vested rights, was that he wasn't entitled to vest in the subdivision ordinance until you had an approved plat. And so that's why we went ahead and had to deny the subdivision plat. And you've been told, of course, that you have the right to appeal that to circuit court. In fact, in the authorities submitted by the appellant, there is also the state law that says under 2261 that you have the vested right only upon approval of a plat, and it goes back to this circuit court. So those are before you and where those issues belong. It is true that this shows that connecting road, but what is also important for you to understand, because frankly it was misstated by appellant, if you could please turn in your zoning administrator handbook, exhibit book to number 4. That is a full copy of the subdivision approval for Section 1. And several times appellant stated that Section 1 and Section 3 were approved without that road. Page 3 of that, and reading the maps and plats are not the easiest, but page 3 at the top, there is a road shown there, and in right-hand side it says Future Fishers Pond Road. That is the connecting road. This plat was approved showing that road. Similarly, on the next page of that same Future Fishers Pond Road is shown down the left-hand side of that plat. There's a line across it, and then Future Fishers Pond Road. That was a platted road in Section 1 being approved. So it's a part of Section 1. It is there and platted. And if I may, we then go to Section 3, which is the side that connects on the other side. That's Exhibit 6 in the zoning administrator. Though please, if you're not following any of this, please interrupt me because I'm happy to respond to anything. In Exhibit 6, page 5 of those plats, sort of in the middle, there's certainly 2 lots shown to the left. It reads, reserved for future road, and the roadway is shown there with a sort of sketched in cul-de-sac, but that is the road that connects across. You can see to the above that there is the line that is the roadway you were just looking at. So Section 3 subdivision plat was approved with the right-of-way showing the road. that connects sections 1 and 3. So it is inaccurate to say that those were approved without this road being shown. They're shown, that road is platted, as I'll show you in a minute on the county GIS. Right here is the county GIS, and it shows the roadway. Each of those parcels have been separately identified, and you can see by the line through it that the road over the bridge is literally been dedicated. So that road exists, it has not yet been constructed. It's not uncommon with subdivisions to have roads that don't yet get constructed, but it exists and is there. The other thing that was discussed by Mr. Walk was the choke point. Through this process, staff came to realize that that choke point, which was not a part of how subdivision accesses were approved in 2007, would prevent the bulk of the lots in 4 and 5 to be. That was never the county's intention. And so on July 2nd, the Board of Supervisors has already referred to the Planning Commission an amendment that specifically says, as to the choke point, a part of the new subdivision ordinance, any subdivision with a pre-approved conceptual plan is exempt from that, because it is not the staff's entitlement to try and prevent Breeze Hill from being developed as it was intended. But we still have the requirement that 2 accesses have to exist whenever you build more than 49 lots. Now, the appellant would like you to believe that they're not aware of that, or that they relied on the fact that they wouldn't have to have that. And for that, let me ask you to go in the appellant's exhibits. Number 4, and it's one of the big plats, so I'll be showing it to you here in just a second. This is the as to section 4, it's just the land clearing permit, so it doesn't lay out the specific, but in large type right here on the right-hand side, prior to the issuance of the 50th building permit within a section, or prior to the issuance of more than 50% of the lots in the section, whichever occurs earlier, the second entrance shall be fully installed, including turn lanes. So from the time that, if not before, they certainly knew, again, they platted the roadway already. When they got this land clearing permit, it says you're going to have a second access when you have more than 50 homes on the road. Now, it is true that the conceptual plan has changed somewhat. They were allowed to build an entrance that came through Lane's End. And so the way the road network is a little different. In fact, that northerly Fairground Roads entrance comes over a little bit more. And there are about 20 or 24 homes, I forget the exact, in Lane's End that sit on that road. What's been built on the road that comes through Lane's End, right now, the Lane's End homes plus what has been built already in Breeze Hill is 49 homes. And so absolutely perfect that they didn't have to build over the dam. They didn't have to build another access. But in order to get another building permit or to have another subdivision plat approved, that's where the second access comes in. All right. The appellant didn't even mention these other issues that were put into their second letter, so I will skip them as well. Let me just double check about going back through, making sure that I have hit some of the areas that I do ask you to read carefully, to the extent you think it's at all pertinent, the May 13 letter, which I would take the position is withdrawn and not before you. But it was suggested to you that that letter says that they're vested completely against 913. The only comment in that letter is about the choke point piece, not 913. With respect to the June 18 letter and the statement that we are not entitled to change it because of an email from me to Mr. Walk in February, in our rebuttal exhibits is Mr. Walk's response to me, which in essence says, "It's nice to hear from you, but I need a letter from the zoning administrator. That's what I need." And that is what you would need in order to try and obtain a right. An email from me is not sufficient. Moreover, though, that 2311, C It's attached as one of the authorities that the appellant has provided. The language that says you have 60 days after which you cannot change it specifically says a zoning determination from a zoning administrator. It's not generic. It says specifically. And as I reasoned to you, this determination, which is what is on appeal, this determination here is appropriate and supported by the evidence, has not been contested on behalf of the appellant. The last thing that I believe I would say is the zoning remains the same. Whether the subdivisions have to be laid out differently because of some later change to the subdivision ordinance, that's decided every year, 2 years, as a subdivision plat comes forward. But we ask you to affirm the zoning administrator's determination that is before you about the zoning ordinance, to highlight to you that the appellant has not offered any evidence that the zoning administrator's determination is erroneous, and just ask that you uphold it. If there's any questions?
Chairman, may I ask one?
Yes.
I just want to make sure all the information is there. The appellant argued a couple reasons why you wouldn't be entitled to make the change in the June 18th letter, whatever. You addressed one just now about the February email, but I don't know that you addressed the one referring to the authority to appeal, that the county did not take an appeal of the May 13th letter. Do you want to address that a little more?
I'd be happy to.
I just want the board to have that information.
Sure.
Your perspective.
In 2311C, and let's just take a look at it since we're going to focus on it. That, again, was part of the appellant's authorities. And so in your record, it's attached to his July 8 letter. In the order in which Ms. Parker made them available to me, his July 8 letter was the 5th document, and that had all of his authorities. The second piece of paper, or second document at least, attached is the 2311. And it's in paragraph C down there that it says, in no event shall the written order of requirement, decision, or determination made by the zoning administrator be subject to change, modification, or reversal by any zoning administrator after 60 days have elapsed. Well, from the May 13 letter, less than 60 days had elapsed. Moreover, the case that we cited to you in which 9 months had passed between the zoning administrator's first interpretation and second interpretation was challenged that it couldn't be overturned, and the court said since the first letter was outside her authority, there is no ability to rely on it, and it can be changed thereafter. It is unfortunate that they use this language. At the end of that paragraph, it says, unless it is proven that the written order, requirement, decision, or determination was obtained through malfeasance. Malfeasance is an ugly word, but it does mean a mistake or outside of the law. And it is unfortunate that based on my error, that letter was issued outside of the zoning administrator's authority. And so because it was issued as malfeasance, the time limit wouldn't apply in any event. The county as an entity, as a party, the county, not the zoning administrators, who I'm in front of you as, did not take an appeal, but the county is not before here either. The zoning administrator, pursuant to that authority, did the correct thing in correcting her letter and to bring it within her authority. So, no, the county did not appeal, but the county is an entity separate from who's before you today. I'm here on behalf of the zoning administrator. And she can change it. She can change it pursuant to this authority. She was obligated to change it because it was outside of her authority. Is there anything else?
Go ahead.
The resolution approving Breeze Hill Proffer A says constructed as generally shown. But the letter, June 18th, says in substantial compliance. And that, can you explain the differences of those two terms?
I don't think they generally necessarily mean something different. They both mean it doesn't have to be exact, but substantially in compliance. So for instance, you know that, again, the Fairground Road was moved in the conceptual plan. But it was still substantially, had 2 exits on Fairground Road. The new exit, Landover planning staff would tell you, was actually in a safer place because it wasn't, and so they approved it. It didn't have to go through rezoning or anything, but it wasn't intended to be a difference in language. Substantial conformity and construed as generally shown, I think are fairly mean the same thing. I also point out, though, that it's in proffer D of this zoning that it says all lots shall utilize the interior subdivision roads to access Fairground. And that's been cited by the zoning administrator in our presentation today as one of the reasons that the layout has to look like this, unless they seek a rezoning or another access, which would be fine. But that would be, again, a different action, not one before you.
Any other questions? Okay.
Yeah, I just had one, I'm not sure if it's for who it's actually for, but Ms. Mee, you'd mentioned that there was a piece of the vested rights that would not be. Is it fair to say that that there would be certain rights that are vested and certain rights that would not be? Or is it sort of like, if you're vested for everything?
No, if you would go again to 12 in the zoning administrator's exhibit. Remember, we talked about Kinlock. You know, they vested under zoning forever ago. The county could not today come in and rezone a section of Kinlock agricultural. Okay, they are vested. However, the subdivision lot layout for each section of Kinlock may look different from the first section that they got approved back in, say, 99 to the section they got approved last year. Because you're not entitled to you're not entitled to be vested against changes to the subdivision ordinance. That's the only thing that changed here, until you have a approved plat. When you have an approved plat, which you can build on for 5 years, then if the subdivision ordinance changes, doesn't matter. You build what the county has already approved. So you do get vested rights in the subdivision ordinance. There is a time after which whatever the county does cannot change how you can build, but it's upon the approval of a plat. For the zoning, you get approval, so 121 lots are legally allowed to be done. And today, the county could not change Breeze Hill to say you can only have 60 lots. But each subdivision then has to comport. Each section they come in with a plat has to comport with whatever today's subdivision ordinance is, which is why the county staff went ahead and put forward that for the board to assign a referral to the Planning Commission to change the choke point. So that wouldn't stop Breeze Hill from developing. Did that answer your question, Mr. Spoonhour?
Yes.
Okay. Anything else?
Thank you very much. Few minutes for rebuttal.
Thank you very much. First of all, I'm going to make every effort not to simply repeat everything I already went through and to address rebuttal points to the county's presentation. First and foremost, the gravamen of our appeal is that the section 9.13 sets requirements which we can't possibly meet based upon the terms of our 2007 zoning approval. Apropos of the question asked by the board's counsel to the county attorney, can you be vested in some things and vested in not in others? And the county attorney's response was, sure, you're vested in your zoning, but you're not vested in subdivision requirements until you get plat approval. True enough, except for this, and that is that the changes that were implemented in section 9.13 conflict with the terms of our zoning. And let me explain how. For example, let's say we were talking about the dam, and the suggestion was made, well, why don't we just move the road off the dam and run it through the spillway somewhere? We can't do that. We actually have frontage out to Shepherdstown Road with Breeze Hill's property, fronts on Shepherdstown Road. We could run an entrance out to Shepherdstown Road. We even tried doing that, but the county said it would not permit us to run the road out to Shepherdstown Road because it did not conform to the conceptual plan, and that in order to have that additional entrance, we would need to go and rezone our property. So the essential point here is not that we're claiming vesting in subdivision requirements. What we're claiming vesting in is the terms of our zoning. And 9.13 conflicts, irreconcilably conflicts with the terms of our 2007 zoning approval. We cannot possibly comply with both. And in support of that, I'll cite two things. One, the zoning administrator's analysis in the May 1 and May 13 letters, which says the essential point upon which the zoning administrator opined that section 9.13 cannot possibly apply to us was because it conflicts with the terms of our zoning. And so we're vested in the zoning, and that's the key point. Second point is the suggestion was made that somehow our request that you strike the one sentence out of the May 13 letter was not included in our appeal. I have a copy of my May 13 appeal letter here. If you look on the second page, I go through the recitation of why it is we say we have vested rights. And then the second paragraph from the bottom of the page says, nonetheless, the department continues to apply section 9.13 to Breeze Hill.
I'm sorry,
The
sir.
letter,
Did you mean May 30th and not May 13th?
I'm sorry, May 30, yes, sir.
Thank you.
Thank you very much. The letter states, and I quote the exact sentence that I'm talking about, the road network depicted on the schematic plan provides every lot in Breeze Hill with access to 2 outlets through the 2 Fairground Road entrances. So I quote in full the exact sentence that I'm talking about in that letter, and I go on in the balance of my appeal letter to state why that statement is incorrect. I also want to react briefly to this Reston case. The county filed this memorandum with all these cases cited, but the only case that was mentioned by the county attorney in her comments was this so-called Reston case. It's up in a circuit court case up in Fairfax County. And in that case, the Board of Supervisors had adopted some amendments to the zoning ordinance, which the zoning administrator opined effectively changed the zoning classification of the property. And when it went up on appeal to circuit court, what the circuit judge said was, no, the zoning administrator can't, by interpretation, change the zoning classification on a piece of property. Only the board can do that, and it can only do it by duly adopted legislation with public hearing and advertisement and all the rest. So that case was light years different from ours in terms of the underlying facts. The county attorney also cited to the subdivision plans on sections 1 and 3 and claimed, well, it shows the road. Well, what it shows is reserved right-of-way for a future road. So yes, the lot owners that buy property in Breeze Hill would have some kind of an easement across that dam if they want to do walking path or walk the dog or ride their bike or what have you. It doesn't mean we're actually going to build the road. And actually, as part of those subdivision plat approvals, we filed and secured approval of detailed road plans showing exactly what it was we were going to build, and those road plans did not include building the road over the dam. Also, as this board knows, when you record a subdivision plat, you have to post a bond to secure construction of your subdivision road and other improvements. Our bond did not include building that road over the dam. And finally, our plat approvals have stated conditions to them. Not a one of those conditions say build the road over the dam. And so that was the basis for my statement that when sections 1 and 3 were approved, we were not required to build that road over the dam. And in fact, it does not exist there today, other than as just the pre-existing dirt farm road, which will remain. Let me react to a couple of the questions that were raised. The county mentioned interesting concession here. The county attorney conceded we cannot possibly comply with section 9.13. As passed with no grandfather clause, we're dead in the water. We can't comply with that code section. So what have they done? Okay, they have introduced an amendment to section 9.13, but that amendment has not even been acted on by the Planning Commission yet, let alone passed by the board. And so speculating on what the board may or may not adopt in the future is not particularly pertinent to this appeal. What is pertinent, however, is the county attorney's concession that we cannot comply with Section 9.13, consistent with the terms of our zoning. We are dead in the water. There was also a question raised by Ms. Coe about the statement of substantial conformity in the letter, whereas the proffer states generally as shown in the plan. What the statement is in the letter and why we didn't specifically highlight that particular issue was it says, in accordance with the resolution contains the proffers, and proffer A contains the language about generally in conformity, and it also contains the statement that specifically reserves the right to change the design of the roads at the time of plan completion and in connection with plat approval. And so I think as fully stated, that would incorporate the full statement of proffer A in shorthand form. However, I would certainly invite the board to clarify that point. And that was language that was changed between the May 13 and the June 18 letters. So the county attorney's attempt to pass it off as just, no big deal, they obviously gave some thought to that because they changed it. And I would encourage the board to change it back to conform to proffer A. And with that, I will sit down and renew my prayer that this board reaffirm the May 13 determination. It was the correct determination. It is the only determination that will properly preserve our vested rights. To further rule that Section 9.13 cannot have any application to our development because it irreconcilably conflicts with the terms of our zoning approval, and to set aside that June 18 letter in its entirety. Thank you very much.
Thank you. Any questions? County rebuttal?
I am glad that I had the opportunity to put before you the Albemarle County Land Use Handbook so that you had something besides just Mr. Walk and I to talk about vested rights, and that you would understand that there's a treatise in land use that recognizes the differences. A vested right in the subdivision is against changes to the subdivision ordinance. In all the cases cited by the appellant, if you have reviewed them, there is a zoning and a change to the zoning ordinance. And that's the vested right that the zoning administrator can stand on. There is no change to the zoning ordinance before you, and that's where the jurisdiction is for this appeal. Asking you to talk about how a subdivision ordinance affects zoning is beyond your purview. It's beyond the zoning administrator's purview. So I would encourage you not to consider that. The actions asked of the BZA is to uphold the determination made by the zoning administrator. And I remind you that the presumption lies with the zoning administrator, and it can only be rebutted by sufficient evidence put forth by the appellant. So we ask for you to uphold the determination and to rule, as you do rule, that your jurisdiction was limited to the June 18th amendment, which spoke solely to the zoning authority. Thank you.
Thank you. Questions? Closing statements from the appellant?
That's what I did.
Oh, that's you've done? Okay. I thought those were both. We're all good. Excellent. Right, no, my bad. Again.
Any further questions from you all?
Yeah, do y'all have, any of y'all questions for anybody we have here? Okay, please.
Is it appropriate to ask the applicant to come forward? Your question?
Yeah, I think anybody you have a question for?
I have a question for Mr. Thompson.
Oh, I'm sorry. Do I need to swear him in?
Just reminding.
Yeah, you hadn't been up here yet. I swear that the testimony I'm about to give is the truth to the best of my knowledge. Thank you.
Thank you, Mr. Thompson. I just had a question. Your attorney stated that the dam road that we're talking about was, in your mind, not anything that was really finalized. But is that correct?
We had always planned to build it back in '06 and
Okay.
But everything changed since then. You know, we rezoned it in '07, and then I built the turn lanes in '08,
Mhm.
and then the Great Recession came.
Right.
And, so we just sat there for 6 years. Well, in those 6 or 7 years, all the dam regulations and everything changed. So, but it was our intention, starting out in '06, '07, we never thought there would be that much to it.
Sure. Just from my understanding, so where the road is now, coming down from the, I guess would be the south side of the lake there, which would be section 2, I believe? Is that right? You-
Section 1.
So could you point to, so to the left of the lake there?
This is section 1.
Right.
Section 2,
So
section 3 is here.
when was section 3 constructed?
2 years ago. A year and a half ago.
Okay, so if there was no road for section 3, why, when I went out there last week, is there hard top up into, going into where the farmer's road is?
Yeah, that's the end of section 3, where the pavement ends. That's the end of section 3.
Right, but the road goes down, like, so I walked the pavement down towards the pond. So if you never planned on building that out, why was there hard top going down that way?
We came in here through Lane's End
Mm-hmm.
and came here and stopped at the 49th lot, which, is.
Right, so I'm talking,
Right around here somewhere.
right, I'm talking about the intersection above, right there, right? So the hard top turns in there. I actually parked there.
That's just a radius, yeah, that's a 25-foot radius.
Okay.
Just turn it. They require that for, on the plans for like a turnaround area.
Oh, okay. That's the only question I had.
Okay. You got one?
I had the same thing in section 1 on the other side.
Oh,
Okay. I've got the exact same thing. Okay, basically it's a 25-foot radius, it just dead ends, and then, we've got physical, like, telephone poles and.
Yeah, there's a tree down.
If the road over the dam could be built, could it be built to VDOT standards?
Absolutely not, no. And one thing, these are all private roads, these aren't VDOT roads, and VDOT will not take any part of a road across the dam, period.
But when you were approved, I think somewhere in there it says all interior subdivision roads have to be to VDOT standards.
To VDOT specs, built to VDOT specs.
Right. Okay, thank you.
But nobody will take the liability of anything underneath the asphalt or gravel on a dam.
Right. Okay.
Thank you, sir. Questions for anybody else at this point? Okay. Would y'all like to go into a closed meeting to discuss this with council? I want to, I'll make that motion.
I move to go into closed session.
I'll second it.
Okay. All in favor?
Aye.
Okay. All right, we're going to take some time to go confer with council. Yeah.
Three, 4-minute recess, 5-minute recess.
Okay, 5-minute recess and then maybe 20 minutes for us to discuss, just since we overshot on the 10 last time. Okay.
So shoot for reconvening it.
We'll be back at 3:30.
Yes, yeah, back here at 3:30. Very good. Thank you. Thanks. I hereby move for certification pursuant to 2.23712D of the Code of Virginia that the Goochland County Board of Zoning Appeals, to the best of each member's knowledge, heard, discussed, or considered only public business matters lawfully exempted from open meeting requirements by the Freedom of Information Act in the closed meeting of this date. and only such public business matters were identified in the motion convening the closed meeting we heard, discussed, or considered by the Goochland County Board of Zoning Appeals. I'll open it for discussion to the board here.
I guess I could start, Mr. Chairman.
Yes, sir, please do.
So first off, thank everybody for coming out. I didn't expect to see anybody but attorneys and maybe the appellant here, so appreciate everybody's interest in this, which hopefully by the time we spent, let you know that we're taking this very seriously, and want to make sure we are weighing everything that was presented to us, which I think we did. For me, it came down to a couple things, and which for my process was, can we even hear this? I think the county did a good job of saying, distinguishing between zoning ordinances and subdivision ordinances. And I think at this point, at least, thankfully, the subdivision, I don't think we can get into the specifics of where you put roads, how the plat's going to be made. So while I think what we heard from some of the testimony, I think was interesting. I'm glad we got it on the record. For me, it didn't weigh in as much as sort of what are we here to talk about? The big thing that we talked about was vested rights, and what are vested rights. And from what I can see, I believe that I don't think there's a lot of argument that the appellant has vested rights. And it's not just a part of it. You can't just say, in my mind, if you're vested in one, you're vested in everything that happens. So you either are vested or you're not. So when we look at, so then the question becomes, which letters did we look at? So we looked at, what did we think was germane in the letters and then could they even be presented? I will say that the one piece that really stuck out in my mind was the language change in the May and June letter. And while the county attorney said that, saying that something is a general issue versus having to substantially conform, I think that's very different in my mind. So that was something that I had to consider while we deliberated.
My biggest issue is, I think it's all about the road. But I didn't feel like we had the authority to just say you can do the road or not do the road. I mean, that's something that's gonna have to be worked out probably in another venue. We did the best we could.
I will just say, kind of for the record, I think we maybe appreciated hearing from the gentleman that spoke on the pond dam expert there, and also the HOA president, but really didn't take any of that into consideration with what we were actually trying to decide and discuss. Of course, we were staying away from, because it's not here for us to determine the subdivision regulations or anything along those lines. So, looking at the vesting and the letters, we did, the language change did stand out, so we tried to figure that out as best we could, and maybe make some adjustments to things to maybe change some of that language back, which not clearly giving a response, let's say, that's exactly what anybody wanted, but the best that we felt like we could come up with.
Not much else to really say. I feel like they've all kind of reiterated what my thoughts were. I will say I think we all drove out there. We all really did research when we got this big thing, so don't think that we just took this lightly. Like, we did really all look into this, and it was a process that we all want it to be built, and it's a beautiful, so, I mean, we're all in agreements that we want this to, it's a great benefit to the county. We just want it done in the manner, so it's going to be beneficial to everyone. Again, the devil was in the details as far as one little word here and one little word here that really can kind of throw everything off. So I hope that kind of what we've come up with is to the best of our ability, good for all parties involved. So with that, I can make a motion. I'm going to make a motion. Okay.
Yes.
I move that the BZA uphold the June 18th letter and that the applicant has diligently pursued the project and incurred extensive expenses and is vested in the Board of Supervisors' resolution and proffers and can develop the project as generally shown on the schematic plan and reverse the zoning administrator's determination that the development must be in substantial compliance.
I second.
Any discussion? I'll just make the comment that that letter in a couple places mentioned, in the first paragraph, that the residential lots, and instead of it saying in compliance with, we were changing that language to as generally shown in the schematic plan, and then essentially twice the word substantial, conformity, and substantial compliance was used, and we used the proffer language we thought was more appropriate there, pulled that, and that's also there would be shown as generally shown on the schematic plan.
I will just say that I don't think it's lost on anyone that this is not ending here, regardless of what happens, and it may wind up in front of us again with different questions and different details, and we just appreciate the thoroughness of both the appellant and the staff to help us come with up to the best determination that we could.
Mr. Chairman, just to clarify the motion, do I take your comment to say that all the references in the letter to substantial conformance or substantial compliance, you would like us, you felt they all should be overturned? Is that a?
Correct, and that's kind of, I think, what she was saying in there. It's mentioned 3 times, the word substantial. Well, the word substantial is in there 3 times. The word compliance is in there once. So maybe I'm at.
You want me to amend my motion?
No, I think we'll take that as
I'm just being clarifying.
You're clarifying the intent of the motion?
Yes.
Okay,
Yes.
I just want to be sure so everyone that walks out here understanding.
Yeah. Any more discussion? All in favor?
Aye.
Aye.
All opposed? The ayes have it. Thank you very much.
Do you have any other business?
Yes, I see that. Where a motion to approve our minutes. Y'all want to discuss them, or?
I make a motion to approve the minutes.
Make a motion to accept them.
Got a second? All in favor?
Aye.
Aye. All opposed? Good. All right, thank you all very much.
Thank you.